to SPLA or not to SPLA, Microsoft licensing for the hosting services provider. I'm Anita Scott, Marketing Coordinator at Scott & Scott LLP. We're an intellectual property and technology law firm located in South Lake, Texas. Your presenters are Robert J. Scott, Managing Partner. Rob represents large corporate clients in high-stakes software licensing, transaction, and disputes. He has defended many SPLA audit matters. Christopher Barnett, Associate Attorney, represents clients in a variety of business, intellectual property, and IT-related contexts with substantial attention to companies negotiating enterprise-level software license agreements and audit settlements. Today's presentation will be recorded and you will receive a copy in the next few days. Please enter any questions in the questions box and we'll answer as many as time allows. For those of you who are wishing CLE credit, we will give the Texas and California bar numbers at the end of the presentation. Tomorrow you'll receive a short survey. We'd appreciate your feedback on today's presentation and your ideas for future topics. We'll begin now. Welcome, Christopher.
Thank you, Anita, for that introduction, and thank you to all of the listeners who are joining us today. As Anita indicated, the purpose of today's discussion is going to be to review the services provider license agreements licensing model that Microsoft offers for hosting providers, and to give everybody an idea about who is a good candidate for SPLA licensing, what types of businesses typically take advantage of this licensing model, what some of the requirements are in order to qualify for SPLA licensing, or some of the triggers that might require you to look at SPLA as an appropriate licensing model for your business, including a discussion of what is commercial hosting, which is a key concept related to those issues, and then also discussing some of the alternatives that might exist for businesses who think they might be good candidates for SPLA right now, but whose business models might make them candidates for other types of licensing that could be more cost-effective or appropriate depending on their circumstances. Once I conclude with that discussion, I'll turn it over to Rob. Rob is going to look at some of the legal issues associated with SPLA licensing, including responding to and defending against SPLA audits that are initiated by Microsoft in connection with your services provider license agreements, estimating the exposure that is related to those audits and some of the challenges associated with those estimates, and then negotiating fair and appropriate settlements to the audits after the audit findings have been prepared and circulated by Microsoft and Microsoft has made its initial licensing demand. First, who needs SPLA? Again, SPLA stands for the Services Provider License Agreement. It's a licensing model that was originally released by Microsoft in 1999, and that was at a period of time when many e-commerce companies or businesses otherwise wanting to take advantage of the internet to deliver their products and services were increasingly contending with the standard restriction that Microsoft and really most software publishers at the time included in their standard retail and volume licensing terms, which in Microsoft's case prohibited the use of Microsoft software for what Microsoft calls commercial hosting services. The primary purpose of SPLA licensed products must be the delivery of hosted or rental software services, so the entire licensing model is intended to allow businesses to get around that commercial hosting restriction, but by that token they need to use the SPLA licensed products principally for those purposes. There is some internal use that is allowed under SPLA, and some service providers actually can use the SPLA agreement to license their entire environment, both internal and client-facing. But there are restrictions on that, so what many of our clients end up doing instead is licensing their hosting environment under SPLA or under one of the alternatives to SPLA, and then licensing their internal use and development environments under different models that might be more appropriate for those purposes. Typical SPLA customers include data hosts, so businesses who offer any kind of hardware as a service options, remote co-location, where you would be making your servers available to your end users, and those servers are running Microsoft products. Those are sort of an ideal fit. Website hosts also would be appropriate SPLA customers for, if nothing else, just the operating systems running on servers where the sites, your customer sites, actually reside. And then file sharing or other data storage or data sharing service providers that want to build their services on a Microsoft-based infrastructure. Also, there are application services providers, so companies that offer hosted backup and data recovery solutions, hosted CRM solutions, and then also hosted messaging or hosted exchange. Obviously, if you're making exchange available to your customers, you need to make sure you have the appropriate licensing in place for those Microsoft products to be used in that way. And SPLA often is a good fit for those businesses as well. And then Scott & Scott also has direct experience licensing under SPLA. We have a software tool that we use in connection with software audits that we perform for our clients, and a lot of the licensing associated with the Microsoft products that are used in connection with that solution is licensed and has been licensed under SPLA. So we do have personal experience with some of these issues, in addition to the experience of just representing clients who are negotiating the SPLA framework. Excuse me. One of the primary differentiating factors or differentiating characteristics of the SPLA licensing model is that in contrast to the standard volume licensing or retail licensing model for Microsoft products, where you would make an upfront, a relatively large upfront capital expenditure to purchase software licenses for all of your infrastructure, and that would require you to project what your needs are going to be into the future to a large extent. SPLA allows the businesses who qualify for it and who sign up for the program to license their Microsoft products on a month-to-month subscription basis. So you're not receiving perpetual licenses as a result of the SPLA agreement, but you are in a position where you can float your usage either up or down depending on the demands that are forwarded to you in the form of customer orders. So if you have a customer who needs 150 Exchange email boxes in 1 month, you report the 150 boxes, and then the next month might go up to 175 boxes, or maybe 146 boxes, and then you just report whatever the appropriate numbers are depending on what it is that your customers are ordering for you. So for the SPLA providers, in addition to just giving you access to Microsoft products for these purposes, it also, for many businesses, provides a licensing model that's a lot more palatable because it allows you to spend for software in direct proportion to what it is that you're using, instead of trying to project what those usage needs are going to be into the future. But in order to get that access, and sometimes by necessity, if you are using the Microsoft products for commercial hosting services, SPLA might be the only ticket for you to continue operating or to operate your business in the way that you plan. The standard prohibition in the product use rights document, which is an addendum to the volume license agreements that Microsoft offers, such as the Enterprise Agreement or the Select Agreement. The product use rights governs your use of software under those agreements, and the universal license terms included in the product use rights state that you may not host the products for commercial hosting services. Unfortunately, neither the product use rights nor any of the standard form retail EULAs or other license agreements that Microsoft makes available in connection with its products, none of those agreements define commercial hosting services. So there's quite a bit of gray area for businesses trying to determine whether they're either eligible for licensing under SPLA or, more importantly for many businesses, whether they have to license their deployments under SPLA or one of the alternatives. Fortunately, like many software publishers, Microsoft also makes available licensing briefs and white papers and other guidance documents outside of the license agreements. Usually those are available somewhere on Microsoft's website, Those sort of satellite documents or guidelines are helpful in the sense that they help to illustrate some of the more subtle licensing concepts associated with its licensing regimes, but they're not directly enforceable against Microsoft like the terms of the license agreements themselves would be. They're not incorporated by reference into those agreements. So for most businesses, they're good guidance, and they're certainly helpful for you to be able to point to them in the event of an audit where you're trying to convince the auditors that you have licensed this software appropriately. But it would be a little bit more difficult to hold them over Microsoft's head in the case of a litigated dispute. That said, if a court were to determine in the context of litigation that Microsoft's agreements are ambiguous, and we have often argued that on behalf of our clients, those licensing briefs and extrinsic guidance still would be admissible, likely, as evidence showing what the party's intent was with regards to these licensing regimes. So they still would be potentially useful in that context, but the goal is really to try to resolve these issues on a business footing, and the principal value for most of this guidance is to help businesses, before a dispute ever happens, figure out whether and how they need to license these products for their particular use cases. A good example, and one of the best examples of the type of guidance that we use in connection with SPLA licensing, is a document that Microsoft, I believe, first released, it was either 2008 or 2009, called the SPLA Qualification Roadmap. And if you go to Google and type in SPLA Qualification Roadmap, then more than likely one of the first few hits that you'll get will give you a link to download the last revision of that document, which was released, I believe, in 2011. The qualification roadmap it takes the form of a flow chart where you start with really broad questions related to whether third parties are even accessing your software and whether they're accessing it anonymously or in an authenticated way. And it works you down through various aspects of your use cases to determine whether you can license these products on an internal use basis or under SPLA or one of the alternatives. After you get past the questions related to third-party access or anonymous access, you really get to the core of the questions related to commercial hosting. Those are questions 4, 5, and 7. So question 4 asks, is the licensee providing access to software applications used for third-party business operations? This is a question designed to sort between the businesses that are providing data hosting or the businesses that are providing hosted applications of some sort. Generally speaking, a yes answer to this question for many businesses will result in SPLA or one of the other commercial hosting rights licensing models being the necessary choice in order to make sure that you're compliant with those deployments. Question number 5, is the third party using the software application as a way to acquire goods or services from the licensee? This question is intended to sort between businesses that use the Microsoft products as a means to an end or as an end in and of themselves. And a good example to a yes question or a yes response to this question would be Amazon.com. Amazon.com more than likely uses Microsoft products in connection with its services where customers would log into their accounts and search for and place orders for various products that are made available by Amazon or by other sellers on the site. And though that technology may be built on Microsoft software, but the software is being used as a means to acquire other products, and it's not being used as an end in and of itself like, say, a hosted CRM solution might be. A no answer to this question, again, will result in the SPLA model or one of the commercial hosting licensing models being more likely for most companies. And then question number 7, does the licensee own the business logic, content, or data and deliver the service under its own brand? This is intended to identify businesses that are acting as outsourcers for third parties' applications that are maybe hosted on a white label basis. A no answer to this question, again, will result in SPLA being the more likely choice for most businesses. In addition to the main flow chart that comprises the roadmap, there's a page 2 to the roadmap that consists of some questions and scenarios the companies can use to try to determine the best way to answer the various questions with respect to their Microsoft deployments. So for question number 4, related to whether the licensee is providing access to applications used for third-party business operations, you would answer the question yes if you're like Company A and you're providing a software application for Company B to use, or no if you're just hosting Company B's website. If you're just hosting a website, then you're really just providing access to data, and there still are circumstances under which you might need to license your software under SPLA, but for many businesses, the subsequent questions would result in an alternative licensing regime, such as internal use with external connectors, for instance, is a common endpoint for many businesses. Question number 5, it's the means or the end in and of itself question. You would answer the question yes if you're like a bank, ABC Bank, using the bank's online banking service to conduct or to allow your customers to conduct their banking online. You would answer it no if you're providing a CRM application for Company B or for your customers to support their customer engagements. So if you're providing that application is the end in and of itself. They're not using the CRM solution to try to access other products or services. And under those circumstances, it's more likely that you would need to use SPLA or some other similar regime. And then question number 7, with regards to whether a business owns the logic, content, or data, or delivers the service under its own brand, you would answer that question no. More than likely, if you're in a situation like Company A here, where you're a travel company with an online presence delivering a corporate travel portal branded in the name of some other Company B, that's a situation where you would be more likely to require commercial hosting rights in order to support those deployments. So for most businesses, when they're looking at the roadmap, assuming that you've gotten past the questions related to third parties accessing your software anonymously, even bearing that in mind, actually, there are 3 principal outcomes for the roadmap. One is just pure internal use. And if third parties are accessing your software anonymously without being authenticated by the server software, then that's a situation where you typically don't even need to have external client licensing. You wouldn't need CALs to support those connections, or external connectors or processor or core-based licenses where appropriate for various products. A good example here would be just a public web page like CNN.com. I think CNN.com has a portal where users can log in, but for the most part, if you're just going to CNN.com, you're looking at news stories posted there, and you're not being authenticated by the servers as a unique user. So you wouldn't need client licensing under those circumstances, and then you also wouldn't need the commercial hosting rights that sometimes go with the client licensing. Outcome number 2 for many businesses would be internal use with external connectors, which I mentioned previously. There is a requirement for client licensing, so either the CALs or the ECs or the processor licenses, but that client licensing and that client access does not fall within the scope of the commercial hosting rights that would require SPLA or one of the other licensing regimes. So an example here again would be Amazon.com, where people are logging into the servers, but because they're not using the Amazon.com service as the end in and of itself, but rather because it's the means to the end being the acquisition of other products that are available through Amazon, and then the way you answer the rest of the questions that follow that typically results in the business not requiring SPLA, but you do need to have some type of client licensing set up to support your users. And then the third outcome for most businesses would be the true commercial hosting operation, where third parties are accessing your software. They're doing so in an authenticated way, and that access requires commercial hosting rights based on the way that they're using the Microsoft software that's incorporated into your solution. A good example here would be any hosting provider like Rackspace.com, where they make their infrastructure available for people to set up any kind of web applications or computing environment that might be based wholly or partially on Microsoft software. The licensing for that software for most hosting providers like that would be coming under SPLA or some similar agreement. Now, the third outcome there, I said you can acquire the commercial hosting rights either via SPLA or via the self-hosted applications benefit that comes with software assurance. This is a relatively recent release from Microsoft. I believe they first made it available in 2009, towards the end of 2009. And it is a benefit that is included with software assurance. So if you have licensed your computing environment under an enterprise agreement or under a select agreement, and the software assurance has been included with those purchases, which would be everybody if you're using an enterprise agreement, then you have access to the self-hosted applications benefit that comes with software assurance. But there are requirements that you need to satisfy in order to use that benefit appropriately. First, it's only available for certain products that are identified in the product use rights. There's a box for the product-specific terms in the product use rights documents that says self-hosting of applications allowed, and then either yes or no. If it says yes, you're good to go. If it says no, then you're going to probably need to be looking at SPLA in order to license that solution. SQL Server and Windows Server in the current product use rights are included, and those commonly are, or those, for many businesses, those are the more common products that are used in connection with the self-hosted applications type service. In addition to the product-specific requirement, you also need to ensure that the Microsoft products are used exclusively in connection with what is defined as a unified solution, which is a solution that's made partially of the Microsoft software that you've licensed under your EA or your select agreement with software assurance, and then partly with what it is that you're adding into the unified solution on your end, your IP. And that the requirements for what you're adding in are identified here in the 4 sub-bullet points under what your software must do. Notably, you can't just have a dashboard or some other bare access to the Microsoft product and call that the second half of the unified solution. You need to be adding significant and primary functionality to the self-hosted applications that are part of the unified solution. So you have to tread somewhat carefully when you're trying to determine whether this is an appropriate licensing alternative for your business. SPLA, for the most part, everybody can buy into as long as you meet the commercial hosting requirements and the other things that we've discussed previously. For self-hosted applications, you need to take a close look at what it is that you're providing to your customers and make sure that it qualifies as a unified solution under these criteria that are set forth in the product use rights. And then also it's very important to keep in mind that all of your client access still must be licensed. Even though you might qualify for the self-hosted, to use the self-hosted applications benefit in connection with your unified solution, that doesn't mean that your SQL Server or your Windows Server deployments are then magically licensed for client access. You still need to purchase client access licenses, if appropriate, or external connectors, or processor or core licenses, depending on what it is that you're wanting to deploy under this framework. And then finally, we have an example here. You might be a provider that has written a file sharing application running on Windows Server hardware and incorporating a SQL Server database. That might be a good candidate for the self-hosted applications benefit. That file sharing application more than likely would constitute the necessary second half of the unified solution, because that's the primary and significant functionality that your customers are accessing with the SQL Server database or the Windows Server hardware, basically they're constituting the back end on which it's based. And then finally, a quick discussion of the various license types under SPLA. And I say various, but there's really only 2. If you've determined that SPLA is the correct license model for your business, depending on your deployments and your use cases, then you need to choose whether to license the software either via subscriber access licenses under SPLA or via processor licenses under SPLA. For subscriber access licenses, these are somewhat analogous to CALs in the sense that they are assigned to authorized users, individual users that are authorized to access the software. But unlike a CAL, they actually permit you to deploy the software on your servers. They permit an unlimited number of software deployments as long as those deployments are accessed only by the users to whom the subscriber access licenses have been assigned. Consequently, the subscriber access license alternative requires relatively strict and centralized server administration so that you can confirm to Microsoft, for instance, in the event of an audit, that no unauthorized access is being made to the product that you've licensed under SPLA, and also so that on a month-to-month basis you are able to accurately determine the number of people who are using the software, accessing and using the software. They are an inappropriate model for companies that might want to cede administrative control over the servers to their customers. Under those circumstances, then you'd probably want to look away from the subscriber access licenses because getting that detailed user information might be a little bit more difficult. Processor licenses for those businesses would probably be the better alternative. They permit access to your deployments by an unlimited number of users as long as the servers are properly and fully licensed. The processor licenses are more expensive on a month-to-month basis, and the accounting can be somewhat more complicated since you're not able to tie the license price to the individual users who are accessing the software. You need to figure out a way to spread that across all of the users who are accessing the per processor licensed software. But other than that slight complication, they're generally much easier to administer in that you know what the hardware specifications are and you don't have to worry about collecting user counts from month to month. And with that, I'm going to turn it over to Rob to discuss some of the legal concerns related to SPLA licensing.
Thank you very much, Christopher. And to the audience, if you have questions regarding the topics that Christopher covered, please feel free to navigate to the toolbar that's provided and type in your questions. And to the extent that we have time at the conclusion of the presentation, we'll begin fielding your questions. And if we're unable to do so, and we will take those questions offline and answer them after the presentation concludes. I think it's one thing is evident from Christopher's presentation is that there are a number of complexities, both technically and legally, in and around the Microsoft SPLA framework and how it relates. And I think the rise of the data center, the rise of virtualization, and the drive for American businesses in particular to move toward software-based interaction with their customers has put a great deal of pressure and focus on SPLA as a licensing model, and in particular SPLA licensing disputes. And I would say that in all of the years that I've been handling software disputes, the SPLA audit is now front and center in the work that we're doing for clients on a regular basis, and I would say is one of the hottest areas in terms of growth for software matters, and therefore a high risk for businesses, both IT services firms and brick and mortar companies that have customers or channel partners accessing their networks. The first issue that arises in connection with a SPLA audit is that when you go to look at the agreement itself, it grants Microsoft very broad audit rights. And Microsoft has been availing themselves of those rights through relationships with a number of third-party firms, including the big accounting and auditing firms, Deloitte, PwC, KPMG, and EY. And what happens is Microsoft sends a letter to a customer that says, you've been selected for audit under your SPLA agreement, and we've appointed fill-in-the-blank auditors to conduct an examination of your computers. And when we get retained early in a SPLA audit matter, what we like to do is focus on two things. Number one, hammering out the scope in terms of geographically which geographic regions are covered, and from a business entity's perspective, which part of a broader corporate family, if any, is to be included as part of the scope of the audit. So one of the things that we generally will look at is the entity that's named in that initial letter, and we definitely want to, as part of our preliminary defense strategies, to make sure that we have hammered out for the client's benefit the scope of the audit, and also to make sure that an agreement has been reached as to the nature and approach to be taken in the audit. Microsoft and their auditors have certain ideas about how these audits should go down, and in many instances we believe that other processes or procedures that vary from their standard approach are more appropriate under certain circumstances. And in particular, the one thing that we've seen in these audit cases is that clients spend a tremendous amount of time unraveling what Microsoft's auditors are compiling. And in many instances, we feel it's more appropriate and efficient for the first aspect of the audit to be conducted as a self-audit, where the client actually comes forward and says, these are our counts, these are our deployments, and if you have a basis to challenge them, then we'll entertain on a limited basis to have your auditors conduct verification work. And the reason I'm so leery about this approach is I've seen it over and over where it's wildly inefficient to unravel the work that the auditors do, and more importantly, in the end, Microsoft wants to give the licensee the tab for all the work. So it can become a bone of contention and an impediment to settling if the most efficient course of action is not chosen in terms of establishing the audit procedures that are going to take place. So those are sort of the two preliminary things that need to take place. After we handle the preliminary aspects of the engagement, the most important thing that our clients are looking to us for is give us a sense of what's at issue here. Have we been in compliance with the licensing rules? And to the extent that we haven't, can you help us quantify financially what kind of exposure we may be looking at in terms of a compliance claim? And estimating the audit exposure in these cases is a multi-step process that starts with the understanding that the license agreement itself is very heavily weighted in Microsoft's favor when it comes to issues related to how do you count damages in an audit matter. And one of the biggest issues is the initial step is to take a base month and say, based on this month that we're investigating, is there a discrepancy, and how much is that discrepancy in terms of dollars? And then what happens is they want to roll back that same discrepancy on a straight line basis all the way to the inception of the agreement. In some cases, we've had claims going back to 2006 because our customers have been long-term SPLA partners. And so that, as you can imagine, when you start looking at a monthly delta that could be calculated on the basis of the current month, and you start extrapolating that backward to the beginning of the agreement, you can see how the audit exposure can amount and amass very quickly in these cases. And I will tell you, of all the audit matters that I've handled in the Microsoft context, the amounts and controversies related to SPLA audit matters are the highest we've seen. And so for both a brick and mortar company, but especially an IT services business that's a SPLA partner, the bulk of your legal and financial exposure may be found in your commercial hosting activities, and likely will be governed by a SPLA agreement. The other aspect of how the exposure can get out of hand in a SPLA matter is this concept of roll forward findings, which is similar to the backward extrapolation in that it's predicated on the base month delta. But now what they do is they say, okay, the auditors originally came in a year ago. It took you guys a year to unravel all the errors and mistakes and discrepancies that you've identified on that audit. And so now we're a year later, and so we want to roll forward from the date of the audit to the time of the settlement that same monthly discrepancy. And again, depending on the number of months that have transpired, that can be a significant issue. And depending on the reasons for that delay, it could work a significant prejudice to the licensee in terms of their legal rights and their financial position. The other thing that the SPLA agreement provides is that Microsoft has the right, under circumstances where there's a greater than 5% discrepancy in licensing revealed by an audit or investigation, that they have the right to charge 115% of the original price. Plus, they have the right, as I discussed earlier, to demand that the audit fees of their auditors be paid by the licensee. So these are the various component parts to what ultimately becomes a demand for settlement from Microsoft. And I can say that in all of the SPLA matters that I've handled, most of the clients that we've dealt with view the initial demands that are based on this model to be outrageous, grossly inflated, wildly inappropriate. You can fill in the blanks, but shock and awe is one way to describe the perception of a target of a SPLA audit when they first are confronted with the types of financial demands that Microsoft is making as a basis of the audit investigation. The typical problem, and Christopher alluded to some of these challenges in his presentation, but it's not that difficult. It's not that simple, rather, to manage a SPLA program in the real world. Depending on your use cases and the way you go to business with Microsoft technology, it can range from very difficult to impossible to accurately account on a monthly basis for precisely what your usage is. And I think Microsoft can play on that, because this snapshot plus extrapolation issue really shifts the burden to the licensee to come forward with evidence and documentation that the actual access or usage or deployment was different than what the extrapolation yields. And because it's difficult to account and because it's difficult to count, it becomes extremely difficult for licensees that are targeted in SPLA matters to rebut the extrapolation and come up with a number that is based on a better picture of reality in terms of the actual use. The other aspect that causes some difficulty is that the Active Directory in many instances becomes the system of record for determining the number of subscribers that were authorized to access in a given period. And anybody who has any experience with managing Active Directory understands that no companies are that diligent in managing the adds, moves, and deletions from that Active Directory list, such that what you have is an extremely high number of user counts that could be grossly, as a multiple factor of those users that actually used in a particular period of time. And we've been in some multi-million-dollar disputes on the issue of whether the appropriate method for counting is actual usage or a more creative concept that Microsoft uses, which it refers to as those that are authorized to access, which in some cases can be a wildly different number with significant legal and financial implications. The other issue that we see in light of the large look-back periods, we're seeing that changes in pricing could affect the ability to calculate the audit exposure. And one example of that is changes in Windows Server pricing that's such that the Windows servers that pricing that was appropriate for the beginning of the look-back period may be different after the pricing has changed later in the look-back period. In the end, most of our clients, whether they're brick-and-mortar companies or IT services or hosting companies, have a broad and long-term relationship outlook with Microsoft. And what that means is that the SPLA partnership with Microsoft is something that is critical to at least some aspect of their business operations. And as a result of that, despite in many instances thinking that they're being mistreated or that Microsoft methods and the approach of their auditors are inappropriate and unreasonable, find themselves in a settlement posture with Microsoft coming out of the tail end of an audit initiated by Microsoft and conducted by their auditors. And so what typically will happen is there will be a handoff that will take place at the end of the auditor's engagement where they're saying, okay, the audit is now concluded, the auditors have conducted their investigation, and now the auditors are going to step aside and present that information to Microsoft, which will then use that information to make a financial demand for settlement. And this is the stage in the process where the shock and awe generally sets in, because the auditors don't signal to the customer during the audit what the financial implications are of the issues that are being addressed and examined. And the first time in many instances that the customer gets any sense for what the issues are and from a financial perspective is after the handoff when the financial demand is made. And so now we are in a situation really of evaluating, okay, we've got this demand, we don't agree with it. It's too high for a number of reasons. Number one, the baseline delta upon which all of the assumptions are predicated is wrong, either because the entitlement information is overly broad or not inclusive in terms of entitlements, and the deployment information is inaccurate in one way or another. If you have either one of those circumstances, your base month delta will be wrong. And then you start from there and looking at the assumptions that are made to roll that backward as well as roll that number forward, plus penalties, plus audit fees, and what you're dealing with is a number that is so outrageous in some cases from the customer's perspective that it becomes very difficult for them to figure out a way to respond. And we've come into cases after the initial demand has been made, and the principal thing that I tell the client that we can do to help them is move them out of a posture of purely playing defense, which is the mode they've been in since the time that the audit started, and now shifting gears to more of an offensive posture where instead of spending all of your time figuring out where Microsoft's auditors went wrong or why their numbers are not workable, coming up with a rationale on your own that will form the basis of a counteroffer to focus on what you are willing to do to preserve the business relationship. And what we find is frequently Microsoft and its customers are talking at cross purposes because Microsoft makes a demand and the customer says, I don't like your demand. And Microsoft says, tell me what you don't like about it. And the customer goes into all sorts of arguments, legal or technical, about what's wrong with it. And Microsoft says, we don't agree with your points. And the customer says, we don't like your number. And Microsoft says, what's your number? And that's where the customer gets bogged down. And so that's why we spend so much time not only looking at the factual accuracy of the audit and the customer's current use cases and their situation, but also evaluating what are your next best alternatives to settlement, which would include terminating the SPLA or moving to a different model, which involves switching costs. And then if you really feel good about litigating some of these issues, which I will tell you many are ripe for the taking in terms of the opportunity to argue some of these points, litigation alternatives and switching costs are really what you need to be benchmarking your settlement proposals against. Beyond the pure financial implications, you want to be thinking about timing of cash flow, a release of liability so that you're not looking at these periods again, some audit forbearance, which would be a concession on Microsoft's part to not exercise their audit rights for a period of time, understanding that the audit process that has just been concluded was burdensome and time-consuming, as well as confidentiality terms related to the nature of the settlement and the fact that no press releases or other information will be shared. In the end, as I said, the vast majority of these disputes will be settled out of court because there's a need for an ongoing business relationship, and when that happens, our client's instruction to us has been, we want to settle this, we want to pay a fair amount for what we owe. We feel like the amount that's been demanded is higher than we feel comfortable with, but in the end we're looking for an out-of-court resolution and a settlement that puts us on an even keel that helps us manage these issues more comfortably on a go-forward basis. With that, I'd like to thank you again for participating in the conference. If you have some questions, you can begin typing those questions there in the sidebar. And at this time, we'll go ahead and open up for any questions that may be pending at this time. So the first question we have here is a question about SPLA audit reporting on a monthly basis. The question says, so if the numbers stay the same each month, would I report the same number each month after month or report a zero usage? Christopher, you want to take that one?
So if your numbers are staying the same each month and they actually demonstrate that you are using that your customers are accessing the software in your hosting environment, you need to report those numbers. So if the numbers are the same from month to month, then that's just what they are. If you get to a position where there are no users of a particular software that you've been licensing on a subscriber access license basis, or if you've decommissioned certain servers where Microsoft products previously installed on those servers were being reported on a processor basis so that they're no longer in your environment, then you could take those off and theoretically you would go to zero usage for the products that were on those systems or that were being accessed by those customers. But to the extent that you have other products still deployed and being accessed by your customers in your hosting environment, you would still need to report those numbers with your monthly reporting.
Next question, if we are considering getting into providing cloud services in the sub 1,000 seats over the next 1 to 2 years, how do we account for potential exposure above the cost of the licenses when we are looking at a pricing model? I would say that the best way to price for anticipated usage would be, wherever possible, to build your financial models on the processor-based model. So that way you're not dealing with a situation where you can get out of line from a budgeting perspective on the subscriber access license challenges that Christopher indicated. That being said, many of our cloud solution provider clients have implemented very tight controls, centralized management, and are in complete control over the servers and have the ability to manage very easily the deployment. And under those circumstances, if you have all of those bases covered, then you could think about the SAL arrangement and you could use that for your analysis. But I think the easier way to calculate it so that you take into account the compliance risks and the need to carefully manage this is for budgeting purposes, plan to have, wherever possible, processor-based licenses. I think that's the best way to handle it. Next question. We have a CRM software that we created on Microsoft Software. It is hosted in a third party on their hardware, but we supply the Microsoft licensing. Our customers' access is through a web browser to manage their sales activities. What is the best licensing platform for us to use? Christopher, you want to take a stab at that one?
There are provisions under most SPLAs, most of the service provider license agreements, that will allow the SPLA provider to use a software outsourcing company to actually host the software on their servers. There are very specific requirements associated with those relationships. But if you can satisfy those requirements, and if it sounds like the Microsoft software, it gets back to this question that we covered earlier when we were discussing the roadmap about whether the Microsoft products are being used to provide access to other services, or whether the products are the services in and of themselves. It sounds from this use case like it might be a situation where you do need the commercial hosting rights that are associated with SPLA. So as long as you can satisfy the software outsourcer requirements that are included in the agreement, then SPLA might be the appropriate platform to use under that environment. When we're reviewing these types of issues with our clients, we typically get pretty deep into the weeds in terms of what exactly are the products, how are they incorporated into the solution that you're providing to your end users, how are they accessed, who's being authenticated. All of these issues are relevant to a decision about how to license the software. But just sort of from a high level, from looking at what's included in this question, it sounds like SPLA would be appropriate, maybe even necessary. But in order to give a really definitive answer on something like that, then we'd probably want to take a real close look at it to make sure that we've got all the facts. Well, I want to thank everybody for participating. If you have additional questions, we'll attempt to deal with those offline. If you want to type them into the chat, we'll deal with them after the session. That concludes the recorded portion of the presentation.